Supreme Court.
Right. Good morning, everybody. Thank you very much. Please be seated. And Mr. Bailiff, please call the case.
Good morning, Your Honors. The matter before the court this morning is a case entitled State of Vermont v. Rodney Lesperance, case number 23 AP 068. Representing the appellant, Rodney Lesperance, is Anthony Don. Representing the appellee, the State of Vermont, is Evan Meenan.
Thanks very much. So I got to get used to the system here, right? Does this work? No? How about that?
Oh, yep.
That works? Okay. Good morning, counsel. Good morning.
Good morning, Your Honor.
Good morning. Thanks for joining us here. And just before we start, and this will not cut into your time, we're so pleased to have an opportunity to sit and hear live cases this morning with students in attendance at Rutland High School. It's a great pleasure for all of us to be here. So having said that, Mr. Dunn, would you please introduce yourself for the record and identify your client and then proceed?
May it please the court, Alex Don of the Office of the Defender General for Appellant Rodney Lesperance.
Thanks very much.
Your Honors, the core issue in this case is extremely straightforward. The court learned that the jurors had been unable to hear the most important part of the defense case, but it failed to take any action to assess the scope of the problem or fix it. While the court admonished defense counsel going forward.
Mr. Dunn, is this on?
Yeah.
Okay. But didn't the court repeatedly tell the defense counsel that he was inaudible and told him to please speak up, yet he did not?
Your Honor, thank you for the question. I have four responses, but two concern factual clarifications and two address the argument itself. First, on the facts, the question, which is an argument that the state made and something that the trial court asserted, actually assumes something we don't know, which is it assumes that the jury's inability to hear defense counsel's questions was a product of the low volume of his voice. That's something the court asserted. However, we don't know, because the court didn't conduct an inquiry, what the jury's problem was. In this COVID-era trial, where even the attorneys were wearing masks and there was an air filtration system going on, operating loudly enough that a record was made about it, we don't know if the jury's issue concerned an N95 mask, garbled speaking that was loud enough but just garbled. We don't know if the attorney was simply standing too close to the air filtration system. So point number one, we just don't know why the jury couldn't hear what it couldn't hear, because the court didn't conduct an inquiry. Second,
Well, excuse me, we do know that the judge himself said he was having trouble hearing.
we do, Your Honor, and I'm about to address precisely that. We do know that on 6 occasions in this 3-day trial, 6 occasions identified by the state in its briefing, during this 3-day trial, the court did tell defense counsel something along the lines of, please keep your voice up. And I went back and yesterday reviewed all 6 of those occasions. And I just want to be crystal clear that, well, there were times when the court said, I can't hear you. That was as strong as the language ever was before the moment in time that is the crux of this appeal. The court said things like, I can't hear you, keep your voice up. But the court never said, if you don't, I'm going to deprive your client of a fair trial, or if you don't, there will be serious consequences, or you're running the risk of defying court order. None of that. This was casual. Hey, we're all in it together. It's a COVID era trial.
Mr. Dunn, but
please keep your voices up.
Mr. Dunn, doesn't that, is this on? Mr. Dunn, so doesn't that always occur during a trial when someone may be speaking too fast or speaking too low, where the court is required to remind the counsel to watch the pace or watch the volume?
They can't hear
Yes,
you, Bill.
if I understand the question correctly, there was nothing in reading this trial unusual about the way in which the court told defense counsel, keep your voice up. It was a very relatively casual, nothing directed or ordered or angry. It was only when the court learned that the jurors hadn't been able to hear that it became a big issue. And I'd just like to circle back if I could, because I do have a few responses to this very important question about what counsel had been told. So just on the facts, again, we've discussed Justice Beebe's question. Did the court tell counsel to keep his voice up? I've said yes, the court did 6 times in a 3-day trial, nothing serious. But more important, at no point in the entire trial, until the moment in time that we're talking about, was counsel ever put on notice that the jury could not hear the evidence that was being presented at trial.
But isn't it the case that the concern that was raised was that they could not hear the question? It wasn't, they were not saying, we can't hear the answer. And as a matter of fact, it appears from the record, doesn't it, that the witnesses could hear the question because the witnesses were offering responsive answers to the questions themselves.
A few responses, and I also still want to complete that first answer, but a few
Yep.
responses. The questions were every bit as important as the answers in this case. And I'll just read 2 questions, and I think they will illustrate why. Question: on the way back, did you think about hurting him or killing him? No. So if you only heard the answer, you would hear nothing or gobbledygook, and then you would hear no.
No.
But if you heard the question, you would hear the defendant say in his own words, in sworn testimony, I did not have the intent to hurt this person. Again, this man was ultimately convicted of aggravated assault requiring intent to injure. The second question, so when you turned around during your version of the core incident in this case, were you trying to stab Nick in the neck? No. If you don't hear the question, the no is meaningless. And respectfully, Your Honor, I understand that you're correct. It does seem as if the witness heard the question. But the whole purpose of the trial is to give information to the jury so they can make a determination on the facts. And if the jury can't hear the question and the answer together, it's really meaningless. These are 4 parts of the case. I'm just going to circle back quickly because I still have a couple more things to say about the first question. So counsel was never on notice that the jury couldn't hear him. Okay? That's.
But didn't the judge keep saying, people can't hear you, we can't hear you? Wouldn't it be reasonable to think that included the jury?
Your Honor, I'll let the records, my recollection of the record, having reviewed it a few times, is that that's actually not the case. It may have happened once, possibly twice. But what happened is when the issue became an issue, the court said things like, counsel, I've been telling you, I've been reprimanding you, I've told you that but if you actually go back and read the record and see what the court in fact told counsel, he said things like, keep your voice up, I can't hear you. At one point I identified in the entire trial, the court said, I can't hear you. And if I can't hear you, maybe the jury can't hear you, I don't know. But the court certainly never affirmatively told counsel, I, the court, think the jury can't hear you. And he definitely never told defense counsel, I know as a matter of fact, the jury can't hear you. And when the court in this case learned that as a matter of fact, the jury could not hear the defense case, and I'll call it the defense case because the question and answer together are what matter, the court did nothing. It did say going forward, keep your voice up after the key witness has already sat down from the direct examination. It did not conduct an inquiry. It did not say who couldn't hear it and how much couldn't hear. But 2 last points on that very first question. Number 1, even if counsel were at fault and he wasn't for keeping his voice too low, and even if we knew that's why the jurors couldn't hear him, which we don't, the proper remedy would be some sort of sanction directed at counsel for, I guess, defying some sort of court order that again never took place. But it wouldn't be to say, we're going to allow your client to be convicted after like the most unfair process imaginable, which is you take the stand, you give your side of the case in this he said assault case involving self-defense. We know the jury didn't hear your side of it, and we don't even care how much they've been here.
Okay, well, I want to step in here if I might. As I understand it, this issue became an issue at the completion of the direct examination of the defendant by defendant's counsel. Is that correct?
Yes, Your Honor.
After that, cross-examination was conducted by the state, correct?
Yes, Your Honor.
Then the defense was allowed to redirect. There was even a comment by the trial judge that this was repetitive, but the counsel was able to put their version of events in a second time in the redirect. Isn't that right?
Your Honor, I see where you're going. I think that had counsel attempted to go back through his entire direct examination again, the court would likely have said, we've already covered that.
It did say that, and then it allowed him to continue.
My point is, the court has the responsibility to ensure that the jurors can hear all of the evidence. And it isn't counsel's responsibility to make up for the court's failing by attempting to resubmit his case in chief in a rebuttal case that's supposed to be only responsive to a cross-examination. The bottom line is, this was the court's fault, and this is Kanzior. We haven't mentioned Kanzior once.
On those lines, the case that you mentioned, I have a concern, and it doesn't really have to do with an issue in the case, but you have used a parenthetical called cleaned up several times. And I've looked that up, and because I'd never seen that before. And what it's supposed to do is to enhance readability and to make sure that it faithfully reproduces the quoted text. And I have some concerns about your use of that parenthetical, where I believe and am very concerned about a misrepresentation of the sites that you're using, because you're taking out language and inserting your own language, which completely changes the meaning of what that case said. And you don't have to respond to that. You can if you want to, but I'm very concerned about it.
I would love to respond, and I'd appreciate it. Or would identify specific, without specific examples, I can't respond, but.
Well, do you want me to read one out
Well,
loud?
I'll just
I don't want to take your time
Well,
up.
I'll just say the last thing I would want to do is misrepresent the law before the court. And if the court does have one, I'm looking at my brief now, and there's a chance at least I'll be able to explain it.
Okay. So the court in a case said that when a trial court fails to investigate possible jury taint, we cannot apply the jury irregularity framework. And your quote says, when a trial court fails to investigate a possible irregularity, which is completely different than taint, affecting the jury's ability to render, it has no basis for determining any prejudice. And then later, the failure to investigate the possible irregularity is what you wrote, but what the court said was the failure to investigate possible jury taint amounts to plain error, and you have that as constitutes structural error and plain error. To me, those are wholly inconsistent.
Very, very briefly, Your Honor, I would just say the cleaned up portion in the parenthetical is not intended to explain my attempt to paraphrase what the court may disagree with is my interpretation of Kanzior. But I don't believe that the words, I think the core, what the court is talking about is the difference between the word irregularity on the one hand and the word taint. If I directly quoted this court saying irregularity when it said taint, I apologize. I hope I was careful in carving the direct quotes out and substituting my perception that the court often referred to its jury irregularity framework in discussing what happened in Kanzior, but it also did affirmatively refer to what happened in Kanzior as taint. And if I got that wrong at any point, I apologize. I would submit on the merits that for the purposes of this case and of the purposes of the analysis, there's no difference between an affirmative taint and where the jury hears something it's not supposed to hear, and a taint essentially by omission where the jury is deprived of information it should have had because of an, in my word, irregularity in the courtroom. In both cases, the jury is deprived of its ability to decide the case on the evidence and only on the evidence. Since I have less than 2 minutes remaining, I reserve my remaining time for rebuttal, but I just want to emphasize no intent to mislead the court at all.
Thanks very much. We'll hear from counsel for the appellee. Please come on up to the podium if you would and introduce yourself, identify your client for the record.
Good morning, may it please the court. My name is Evan Meehan and I represent the state of Vermont. I was warned my height might be problematic.
Thank you.
Is this working?
It's
Yeah.
working, yeah.
Okay, fantastic. As I just stated, I represent Vermont, which in this case is asking the court to affirm appellant's conviction for assaulting his former roommate by stabbing him in the neck with a fillet knife. There's two issues regarding audibility in this particular case. I'm hoping that I will have time to address both of them, but I'm going to start off by addressing the issue concerning whether or not the jury could hear defense counsel at all times. And there's 4 facts that I think are really important when considering this issue. And the first of which reveals that this issue was brought to defense counsel's attention way before the direct examination of appellant. Specifically, the issue of defense counsel failing to consistently speak audibly first arose during the jury trial. Okay? The court flagged it 3 times for defense counsel that it could not hear them speaking. And a juror flagged it 1 time. So this rebuts the argument that defense counsel was not on notice that their inability to speak audibly could compromise the ability to present their case. The second fact is that during trial, the court told defense counsel 6 times that it couldn't hear them, and not one of those times occurred during appellant's direct examination. After appellant's direct examination, the court relayed to defense counsel that the jurors were having difficulty hearing the defense. That's the third fact. And the fourth is that even after that specific warning, during what appellant is saying is the most important part of the case, the court warned defense counsel 3 more times that it still was having difficulty hearing.
So, Mr. Meehan, I understand the issues and they were raised clearly by the court to the attorney. Isn't the real question, though, is whether or not the court should have made an inquiry to the jury directly on the record, indicating whether or not they were having difficulty hearing questions, or if they were having difficulty, that it was needed to be remedied some way during the trial?
I think that goes to Justice Carroll's point at the end of appellant's argument about Kanzler. In that case, the issue was whether or not the jury was overhearing bench conferences. And what this court said was that, quote, the duty to investigate occurs only when the trial court discovers the possibility of jury taint. I think that there is a real question as to whether or not jury taint pertains to the jury being privy to extraneous, impermissible information, such as things that they overhear during bench conferences, or things that they decide to research on their own in contradiction to the court's instructions. I'm not sure, and I don't think that this court should conclude that jury taint always includes missing information. At a minimum, in a fact pattern like this, where there's an indication that the fault lies entirely with defense counsel who failed to consistently speak audibly after being told, what, 10 to 12 times?
Well, let me jump in for a second on that. You say the fault lies entirely with defense counsel. Let me push back. Under the rules, the trial court has got an obligation, a duty, a responsibility to make sure that the evidence is introduced in a cognizable fashion in accordance with the rules. We don't have any representation here that the trial court made a special effort to find out from the jury exactly what they were talking about and discuss the matter in more specific terms with the lawyers off the record, do we?
Well, I think again, it goes to which case is going to govern the outcome of this particular issue in this appeal, right? On the one hand, the appellant would like this court to apply Kanzior and say, when the jury misses information, admissible evidence, potentially misses admissible evidence, due to defense counsel, then that constitutes that's equivalent to jury taint and therefore structural error. The state's contention is that the omission of evidence is not the same thing as taint by extraneous information, and the more correct case to govern the outcome of this issue is the McAllister case. And in McAllister, what this court said was that when the court receives a note from a jury, the court's obligation is to disclose the note to the parties and give them an opportunity to respond to it. And that's exactly what the court did in this case. It said, after having previously warned defense counsel several times, it said, I just received a note, this is what it says, and I'm again directing you that you need to consistently speak audibly. I mean, for example, and for whatever reason, defense counsel was unable to make the accommodations that were necessary. I'm making accommodations right now by leaning into this microphone.
Well, and we appreciate that, Mr. Meenan, but let me just, my point is, I don't think you, in your position, can hang this all on the lawyers, and I don't think we can let the trial judge off the hook. It is the trial judge's ultimate responsibility to make sure that the evidence comes in an appropriate way and that the jury is hearing it, and I'm just not sure that there's a record of the court going out of its way beyond admonishing defense counsel to ensure that that was taking place.
Well, I would agree with you that aside from the admonishments, the court, the repeated admonishments, the court did not inquire directly into the jurors.
Right.
Which specific questions did you not
Right.
hear?
Right.
However, that again goes to, I think it was Justice Eaton's point, which is, okay, well then what would the court have done about it had it inquired of the jury? What would the next logical step have been? The next logical step would have been, defense counsel, you can re-ask those questions. And as Justice Eaton pointed out, it had the opportunity to do that on redirect, which occurred after the court notified the defense counsel of the jury's note. So even if it wasn't entirely defense counsel's fault and the trial court should have took additional action, we have to consider, was this plain error? And I think because defense counsel had an opportunity to re-ask those questions, the answer is no. I'd like to turn to the—
Just one quick question regarding that, and that's the COVID issue, that you've got an air purifier going on, you've got everyone wearing masks, and how should that be factored in the audibility?
Well, I think that that should be factored in two ways. The first way is sort of a caveat, which is and this is in response to the cases that an appellant relies on, and the state's assertion that those cases are not dispositive. And some of those had to do with similar issues where there are fans going on or jurors sleeping. But the difference between this case is that in all of those cases, it wasn't defense counsel who they were having trouble hearing. It was the actual witnesses that the jury was having trouble hearing. And there's no indication in this particular case that the jury was having difficulty hearing anybody aside from defense counsel, even after defense counsel was repeatedly warned that they needed to make adjustments because of the limitations that we were all dealing with in court during COVID. Turning to the second.
Let me jump in. You know, that is the remarkable thing about this case it's distinguished from Kanzior, all the cases that the two of you are citing. We had a situation that was taking place in this state when we were doing everything we could to try to make sure people's due process rights were honored and respected. Yet, at the same time, in order to make sure that the proceedings were taking place, you had to wear a mask, your opposing counsel had to wear a mask, the jurors had to wear masks, they had to be separated from each other. These are unique circumstances that are not represented in any of the authority that we're talking about here this morning. And I think it's a genuine concern that we don't have a trial judge who's taking greater control over the process themselves. That's my point.
I agree that COVID was unique, and hopefully a case like, for that reason, hopefully a case like this will never come back before the court. I think both sides could say that they hope that that happens. But I would like to take some time to address the first audibility issue, and that pertains to the allegation that the jurors were overhearing defense conversations. During the trial, the state informed the court, quote, that we are trying to figure out the logistics of this microphone because apparently when we put our hand over it, it's still picking up our conversation. So under Cansior, the court may have had an obligation to follow up and investigate whether or not the jury was overhearing the state's conversations. However, appellant is not seeking reversal of his conviction on that basis. The state's contention is that the court had no such duty with respect to the jury potentially overhearing defense conversations, because as we've been discussing all morning, the jury was having trouble.
Mr. Meaden, I'm sorry for interrupting you. I know you want to get some points across, but what you just said in terms of defense counsel not appealing that issue before this court. So are you telling this court that it's not preserved?
I'm saying that, well, I have to go back and check the record, but I don't believe in the record that that the defense counsel made an argument that he was entitled to a new trial because the jury overheard the state's conversations. All of the arguments were based on the jury allegedly overhearing defense counsel conversations, and in their principal brief, I don't believe that the appellant argues that his conviction should be reversed because they overheard the state's conversations. Okay. And this court's precedent is clear that matters not briefed will not be considered. So the issue really is, should defendant's conviction be overturned, and should he be granted a new trial because the jury potentially overheard defense counsel conversations? And as we've been discussing all morning, the jury allegedly was having difficulty hearing defense counsel even when they were trying to confer. So there's no reason to conclude that the court had reason to believe that the jury was overhearing defense counsel when they were trying to speak confidentially amongst themselves and with their client.
Didn't the trial judge offer some alternatives for the defense to try to give them a way to communicate between attorney and client without being overheard, which the defense counsel did not avail himself of?
You're absolutely correct, Justice Egan. There was two options that the court pointed out to defense counsel, one of which I'm assuming any trial attorney has used in the past, which is communicating in writing. Post-it notes, note paper. Anyone who's tried a case with co-counsel or a client has likely used a method similar to that. And there's no adequate explanation from appellant as to why that was unsuitable in this particular case. The second option that the trial court presented to defense counsel was, we can take breaks. If you need to have a confidential communication, you can take a break, you can step outside, you can find a room, and we will make time for you to have those conversations. And the record does not establish that defense counsel took advantage of any of those opportunities. Instead, they just moved for a new trial. In addition, related to the second audibility issue, I think that there is an important distinction with the Cansior case. In that case, when the court was alerted to the fact that the jury might be overhearing bench conferences, the trial court instructed the jury to simply ignore that. But this court in Cansior did not consider the impact of the other types of jury instructions that were discussed in the state's brief. And those were jury instructions pertaining to the fact that the jury was only permitted to base its verdict on the evidence and the definition of the evidence, which certainly did not include any overheard conversations between the parties. And because jurors are presumed to follow instructions just like those, I think that this court is obligated to presume that they did not base their guilty verdict on any conversations that they may have overheard between defense counsel or defense counsel. I would like to, in the few moments that I might have for meeting, I'd like to address the fourth issue in this case, which is the refusal to take judicial notice of Mr. Beaudry's dismissed DUI. That is another example of the court giving defense counsel alternative options, and I see my time is out, but thank you very much for considering my arguments.
Thank you. Thank you very much. Counsel, does the appellant have time?
Appellant has 1 minute and 21 seconds remaining.
Counsel?
Thank you, Your Honor. Two very good. First, the state just represented what the next logical step would have been had the court conducted an inquiry. We don't know what the next logical step would have been because the inquiry didn't take place. Whatever information it revealed would have determined what the next logical step was. And then second, unlike Cantior, which did involve an extraneous potential taint, no jury instruction could possibly cure what happened in this case because the jury didn't hear the defense case, questions and answers together, and there's nothing the court could have possibly told the jury.
Then what about the ability to listen to the testimony again? They always have the right to do that. Jurors do it, ask for a read back or a tape back. And couldn't they, that was part of the instructions, was it not?
I believe it's part of the instruction, but the jury did take an effort to, in some form or another, inform the court in real time that it couldn't hear what the defense had said. And for whatever reason, the court took no action, and the jury may well have concluded that was all it was going to get. Court has no further.
I have a question, actually, Mr. Dunn. Is it possible that perhaps your client's remedy is really a motion for post-conviction relief based on his attorney's conduct during trial?
I don't believe so. I don't believe so, Your Honor. I don't see how counsel's possible inability, again, we don't even know why the jury couldn't hear what they couldn't hear because of the lack of inquiry. But even if it was the volume of counsel's voice, that's not the type of legal error that arises to ineffective assistance of counsel. He was clearly trying to do his job. This was his witness on the stand, giving his side of the story in an assault case involving self-defense. There's nothing.
But didn't he say he was afraid of alienating the jury if he spoke too loudly, that they think he was yelling at them?
I know there was a colloquy with the court about that, but to the extent that that's the case, that might suggest that there was a strategic reason for what he did, and that an ineffective assistance of counsel motion may not be the right way to go. But the bottom line can't be that he had, well, it's for this court to decide. My submission is that it can't be that he has no remedy for the fact that the jury couldn't hear his side of the story. Counsel is doing his best to through his mask and the air filtration system to elicit the evidence that this was what the defense wanted the jury to hear. This, from their perspective, this was the whole point of the trial. So there's nothing about counsel where he would have tried to sabotage his own case. It just doesn't make sense.
Okay. Your time has expired. Thank you very much. Please call a conclusion to the hearing.